How do I file for a temporary order hearing in Claremore? A temporary order hearing allows the judge to establish rules that govern the parties in a family law case while the case is ongoing. These orders can address matters such as child custody, visitation, child support, spousal support, possession of the marital residence, payment of debts, and other issues that require immediate attention. For many families in Claremore, a temporary order hearing provides stability during what can otherwise be a lengthy court process. The temporary orders remain in effect until they are modified by the court or replaced by the final decree or final custody order. Step 1. File the underlying case. Before requesting a temporary order hearing, there must generally be an active family law case pending before the court. Temporary orders are commonly requested in divorce, legal separation, paternity, or custody proceedings. The case must first be filed with the Rogers County District Court and assigned to a judge. Once the case is filed, either party may seek temporary relief from the court if immediate decisions need to be made regarding children, finances, or property. Step 2. File an application for temporary orders. The next step is to file an application for temporary order, or similar motion requesting the specific relief sought from the court. The application should clearly explain what orders you are asking the judge to enter and why those orders are necessary. For example, a party may request temporary custody of the children, a visitation schedule, temporary child support, temporary alimony, exclusive possession of the marital home, and payment of certain bills during the litigation. The more specific and organized the request, the easier it is for the court to understand the issues that need to be addressed. Step 3. Obtain a hearing date. After filing the application, the matter must be presented for scheduling so that a hearing date can be assigned. Oklahoma law generally requires the court to schedule a temporary order hearing within 30 days after the application is presented for scheduling, unless the parties agree otherwise. If domestic abuse allegations are involved and statutory requirements are met, the hearing may be set within 10 days. Many judicial districts maintain a temporary order docket specifically for these hearings. Step 4. Serve the other party. The opposing party must receive proper notice of the hearing. Oklahoma law generally requires at least 5 days' notice before the hearing, unless a specific exception applies. The court cannot ordinarily enter temporary custody, support, or property orders until proper notice has been provided. Service requirements are extremely important. Failure to properly notify the other party can result in delays or the hearing being continued to a later date. Step 5. Prepare your evidence. Although temporary order hearings are usually less formal than a final trial, they are still important court proceedings. The judge may hear testimony, review financial documents, examine proposed parenting plans, and consider evidence relevant to the issues before the court. You should gather any documents that support your request, including pay stubs and tax returns, child care expenses, health insurance information, school records, text messages or communications relevant to custody issues, and evidence regarding household expenses and debts. Temporary orders often set the framework for the remainder of the case, so preparation is critical. What happens at the hearing? At the hearing, both parties have an opportunity to present evidence and explain their positions. The judge will then decide what temporary arrangements should be put in place while the case remains pending. Common issues addressed include temporary custody schedules, visitation, child support, alimony, possession of vehicles or homes, and responsibility for ongoing bills and expenses. Once entered, the temporary order becomes a binding court order. Violating the order may result in contempt proceedings or other sanctions. Claremore family lawyers. Temporary orders often have a significant impact on the final outcome of a family law case. The parenting schedule established at the temporary hearing may remain in place for months, and temporary financial decisions can affect settlement negotiations and trial strategy. Courts frequently look at how the parties performed under temporary orders when making final rulings. Because temporary order hearings can significantly influence the direction of a case, individuals seeking temporary relief should consult with an experienced family law attorney as early as possible. For a free consultation with an attorney at Kania Law, Claremore Attorneys, call 918-379-4872.